Hi there, I'm attorney David Drwencke from DRD Law. I appreciate you coming and watching another video. Today we are talking about self-defense. Self-defense is probably one of the better known affirmative defenses to even lay people, folks who aren't attorneys. We've probably heard of that term, self-defense. And we have kind of a basic understanding. Listen, somebody attacked me. I have a right to defend myself. Isn't it that simple? Isn't self-defense just me protecting myself? And on one hand, yes, it is about that simple. And on another hand, no, it's not. Case law, the legislature has made it a little more convoluted. There are actually multiple factors that need to be shown by the defense in order to prove a sufficient and self-defense claim in a criminal case. And that's what I want to go through today, is some of the ins and outs of what is involved in a self-defense claim, because it is usually misunderstood or overly simplified would be the way I would word it. People have a misunderstanding, or they just think it's a little more cut and dry than it really is. We're going to go through those elements for which, in the use of lethal force, meaning you actually use force that cause death or great bodily harm. There are 6 total, but the first 4 or 5 actually apply to any type of self-defense claim, meaning even if you didn't use lethal force, a gun or a knife or some weapon like that, you still have to prove a number of these elements in order to show or convince a judge or a jury that this was a self-defense case. So as a starting point, self-defense is something that the defendant, has to actually tell the state that they're going to argue at a trial. Be it a bench trial with a judge, which is when there's only the judge making a determination on guilt or not guilty, or at the traditional jury trial where there are 12 individuals that make the ultimate decision. They're called the fact finder. They're the ones who hear the evidence from the state, the prosecution, and from the defense. And after all the evidence is in, testimony and exhibits, they make that ultimate decision. Who is right? What are the facts? They make that determination. Well, self-defense is what's known as an affirmative defense, affirmative defense. There are a few different affirmative defenses, and we'll do videos on those, but the best known is self-defense. The other would be alibi, and alibi is largely where you're saying, listen, I didn't commit this offense, and I couldn't have committed this offense because I was somewhere else, and I have someone who will confirm that, or there's video that I was somewhere else, be it a different part of the state or another country or another state entirely. And we'll do a video on that. But the other is self-defense. And that's one we have to plead. We actually have to put it in our answer to discovery. We have to let the state know that we're going to be doing this. And then we have to go about actually proving it. These are elements that the defense has to put on evidence of in order to be successful, to show that this was actually self-defense. So what are those 6 elements? We're going to go one at a time, and I'll describe what they mean and what we would have to show. First is that force was threatened against them being the defendant. And so force is being threatened. Well, that can be shown in a few different ways. One is that there literally was force being used. Somebody was punching or kicking or shooting at you or using a knife or something like that. They were quite literally using force. But there's also an example where it's just being threatened. Kind of the classic example, what we learn in law school, and an example I would give to a client is somebody with closed up fists, red face, they're scowling, and they're moving towards you, and they're raising their hand, and you believe you're about to be punched. That is a threat of force against my client. Words usually aren't quite enough unless there's some action behind it. And we're going to get to another element where that comes more into play. Second factor, that the defendant was not the initial aggressor. The idea here is that you didn't start a fight. Whoever this other individual is, didn't then come back at you, and now you're saying, well, they attacked me. They came after me. I was defending myself. The law says, well, wait a second. If you start the fight, you then don't get to defend yourself and say that you're without fault and you should be found not guilty. You cannot be the initial aggressor. You're not the one who's supposed to point a gun at them and they come back at you and then you fire the gun. Or you're not the one who punches them and they come back at you and you continue to use more force. They have to be the initial aggressor. Whoever the state is alleging is the victim, the person that you've punched or kicked or shot or stabbed, hypothetically. You cannot start that fight. Third, that the danger of harm was imminent. Now, this goes back to something I said earlier, where somebody may make a threat. They're going to say, I'm going to punch you the next time I see you. Or they send you a text message, I'm going to slap you or shoot you. Now, those are all inappropriate things to say. There might be legal recourse against that person for making that kind of threat or threatening your life and so on. But just merely making that statement or talking about a future date where there may be violence, that's not enough. If somebody sends you a social media post and the next time you see them, you shoot them, and then the claim is, well, they threatened violence against me. They threatened my life. It's like, well, that was an uncertain amount of time. It was in the future. We don't know if it was in jest or sarcasm or any number of things, or cooler heads have prevailed and so on. So it has to be imminent. It's happening now. You are facing the danger now. You've been injured or you're about to be injured. Now it's imminent. The fourth element is that the threatened force was unlawful. So the idea here, the example I oftentimes give clients, would be in the situation where a police officer is arresting someone. That officer is using force. They're putting your arms behind your back. Maybe they're pinning you to the ground. They're going to put handcuffs on you. They're certainly using force. They're touching you, probably in a way that you do not enjoy or like. You feel threatened. You are unhappy about this. In fact, it probably hurts. Maybe you have an argument that's even excessive force. But in that moment, and in most situations, and of course we'd have to litigate it out, but it's that they're using a legal use of force, that you're under arrest. And the police are given that power. They're given the ability to make physical contact with somebody when they're being arrested, to put their arms behind their backs and handcuff them and so on, and use force to put them in the car and get them out of the car and so on. Obviously, we want the police to not use excessive force and to be polite and professional, but they're allowed to use that force. So you can't then say, well, I didn't really like this arrest, or I thought they got a little extra violent with me. And again, maybe they did, maybe they didn't, given the set of facts, but that doesn't then give the defendant the right to say, well, that's why I punched him. I punched the officer because I didn't like the way he had touched me. It's like, well, the argument from the state or the counter to that is, well, no, that was a legal and justified use of force. You're not allowed to defend yourself against a legal use of force. And there certainly are other examples. That's probably the more classic one. Number 5, that the defendant actually and subjectively believed a danger existed that required the use of force. Now, again, this is really putting the jury or the judge in the shoes of the defendant. What did they believe? What were they feeling? What did they think in the moment? And that's why in many, if not all, self-defense cases, the defendant usually has to testify, which is usually against my rule of thumb and expectation that a defendant won't testify. But the only way to get into your head and how you were feeling and what you were thinking and why you did what you did is to testify, more often than not, though there can be some examples where a previous statement or recording can be used to benefit a client. But that this point is about that they actually believe this, that this force was about to be used on them or force was being used on them, and that they subjectively and actually they genuinely believed that this danger existed and that they had to use this force in order to defend themselves. Number 6, and largely, in my opinion, many self-defense cases are won or lost on this factor. Not that there aren't oftentimes arguments on all of these factors, but it's the 6th one that can prove to be the most difficult. Their beliefs, the defendants, were objectively reasonable. So now we're taking a step outside the shoes of the defendant or the accused. We're asking or having to prove to a judge, again, at a bench trial or a jury at a jury trial, listen, anybody would have reacted this way. It's not just what the defendant thought and how he or she felt on the date and time when things were going on. It's anybody would react this way objectively. If you were put in this position, if anyone was put in this position or this situation, this is how you would react. That you would punch back, or you would shove, or if you were equipped with a weapon, be it a baseball bat, knife, or gun, you would use that force. Objectively, anyone would do this if facing a similar set of facts. And that can prove difficult. Not impossible. Have won plenty of self-defense cases. But this is the factor where I think the state spends an awful lot of their argument. It's either on who the initial aggressor was, or it's on this objective sixth factor of, would anybody do this? Was this the appropriate way to react? Were there other options, and so on? But those are the 6 factors that are on the defense in order to prove and show evidence of at a trial. There's certainly more that goes into a case like this. Obviously, we talked about who the initial aggressor was, who started this fight, who started the use of force. There are motions relating that. One is called a lynch motion. Lynch motion gets into the criminal history, or specifically the violent criminal history of the alleged victim. Be it they could be dead if they're the decedent, allegedly of victims who had been shot or stabbed and they died. Well, we can get into their history and say that they were a violent person if there's a question as to who started this fight. It certainly can still be relevant if the person was just injured and they're alive and they're going to testify, but there's still this question of, well, who was the initial aggressor? Who started this? Well, the criminal history of that alleged victim, and maybe they're not a victim at all, that becomes relevant. So a lynch motion, we get into that. There are certainly other pretrial motions and concerns and things that we get into. Self-defense can be shown through most of these elements, but that it was an unreasonable use of force, where maybe people believed you were defending yourself, but used too much force, or you didn't use like force, that somebody was slapping you, but then you pulled out a gun and shot him in the face. It's like, well, was that reasonable? Was that like force? Did you have to shoot them in that situation? Were you facing great bodily harm or death? That's part of the calculus there, that especially when we're talking about the use of deadly force, that's an added component to this, that not only were you facing a threat of force, but you objectively and subjectively believe that you were facing great bodily harm or death based on the threatened use of force or the actual use of force. There's a lot that goes into these. As you can see, it's a little more complex than what I think we assume that it is. But these are the types of cases when it comes to violent ones, be it domestic violence, low-level, even misdemeanor batteries, up to and including murder cases in the discharge of a firearm or the use of a deadly weapon, again, like a baseball bat or a knife and so on, that I have tried multiple times. I've nothing but experience in this, and we've been successful in winning self-defense cases because we understand the law. We know the case law, we know the factors, and we can start to analyze a case from the very beginning through the prism of how do we prove self-defense? What evidence do we need? How do we prepare our client, and so on? Naturally, there's a lot more that can be shared in just a video of maybe 14, 15 minutes long. If you have questions about self-defense, contact the firm. That's what we're here for. We want to answer questions. If you or a loved one are facing a case and you want to plead self-defense, talk to an expert. And that's who we are at DRD Law. If you stuck around this long and you have other questions, criminal law related, send a message, comment on the video below, let us know what you want to learn more about, because that's what we're here for. Again, this is done as a public service. I want to inform the general public. I want to provide a little bit of insight and some context on criminal issues and law that I believe are oftentimes misunderstood, or certainly more complex than they're led to believe. Again, we're experts on criminal law. This is what we do each and every day. I appreciate you taking the time to sit down and watch this video. Contact the firm if you have any questions. Otherwise, have a great day, and I'll see you soon.